You should be in.
Good afternoon, everyone. My name is Don Hemrick. I'm the Director of Development with Trees Atlanta, and I want to welcome everyone today to this adult education seminar on estate planning and legacy giving basics. As you may or may not know, this week is National Estate Planning Week, and we're very fortunate to have with us today Laurie Busbee, who is an attorney who focuses on estate planning with Legacy Studio Estate Law here in Atlanta. I was fortunate enough to meet Laurie when Trees Atlanta was one of 10 nonprofits who was fortunate enough to receive a bequest when a prominent doctor passed away a couple of years ago. And we want to share this knowledge from Laurie with everyone. She helps guide clients through the estate planning process. She also helps guide administrators through the probate process once a loved one has passed. So, logistics, we will be recording this session until we get to the Q&A, and then we'll stop the recording. However, we will include with the recorded session the notes from the Q&A as well when we redact everything that might have any personal information on it. So without further ado, I'm going to bring up Laurie.
Thanks, Don. I really appreciate the introduction, and I really am honored for the opportunity to come and speak to Trees Atlanta's members. This is a fabulous organization. I live in the city of Atlanta and benefit from your work around town, and I'm just really pleased to be here to help with this. So I'm going to talk about generally estate planning, why we should have it, what it involves, and then also talk to you about how you can make charitable gifting part of your estate plan, different ways that you can do it. So with that, let's get rolling. The first part of this is we have a disclaimer. All right, something's happening with my slides. There we go. All right, so just to be aware, you participating in this presentation today doesn't mean that you and I have a attorney-client relationship. I definitely want you to consider taking what you hear here and speaking to another attorney about it, myself or somebody else that can help you with your personal situation. Everybody's family situation and asset situation is different. And my recommendations here, while they are intended to be general, may not apply in your particular circumstance. So you should definitely think about consulting with an attorney. And my information is here with the slides at the end. If you have any interest in talking to me, I can provide your worksheet and help you get started here. And like Don said, we're going to save questions till the end. So make some notes, think about what it is that is important to you that you want to know, and feel free to ask. I'm happy to stick around at the end of this to talk about anything that you all have of concern. All right, so with that, let's talk about why estate planning matters. So the thing about estate planning that a lot of people don't think about is that it not only deals with what happens to everything after your death, but it also creates a plan for incapacity. Some of us in the future are going to reach a spot in our lives, be it for a medical diagnosis or an accident that's happened to us, where we may experience a period of incapacity, temporary or permanent. And your plan that you put in place through the documents that we're going to talk about today will help prepare your family for that, as much as it will help prepare your estate and what's going to happen with it after your death. It really is an act of love for you to do your estate planning. So the estate planning matters because it ensures that you get to decide who's in charge of your estate. You get to choose who the executors are. You get to decide who benefits from your legacy, your hard work, and the assets that you have earned over your lifetime. Maybe you don't want them to go to the same people that the state would say should inherit your assets if you didn't have a will. So take control, and creating your will is you taking control of your power to be able to decide who's going to be in charge of things and who's going to get things. And it also is an opportunity to make sure that your values are expressed with your legacy. So if you have charitable organizations that you care about, or you're just generally charitably inclined, it is a great opportunity to make sure that those wishes are carried forth after your death. And most importantly, what I see with clients when they come to my office and do their signings and they leave our office is they tell me, whew, now I have peace of mind that everything is taken care of. I mean, we sort of call ourselves a peace of mind specialists. I mean, they're really, if you think about all the time in your life that you have spent saying, oh, I need to get a will, I need to take care of this, and there's nothing in place, you could, if you took care of this and got it done, you could get all that time back and not be worried about it and have the peace of mind that it's done. So, and I just can't express enough that having your own estate plan in place allows you to give money with a purpose. You can set the guardrails around who gets what and what they use it, what it's used for, to the extent that you have any particular desires. It's all part of that aligning your values with your legacy piece. So moving on, let's talk about what makes a part of what are the core estate planning documents. Every client that comes into our office that doesn't have any estate planning in place, we encourage them to leave with, and our packages typically include a healthcare directive, a power of attorney, and a will. Circumstances may make it so that a trust may make sense, and we're going to talk about the difference between wills and trusts here as we go further into the presentation. But the three core documents are the healthcare directive, power of attorney, and the will. They are generally state specific. Every state has its own requirements for wills with as far as validity. So they have different, like Georgia has an affidavit that goes on the back of the will that witnesses have to sign, and it has to be notarized, and people have to swear to certain facts so that when the will gets filed many years later, that information is there before the court. And if it isn't there, then somebody may have to go back and find the witnesses that signed your will many years from now, and they may not be easily found. So making sure your will comports with the state law will save your estate and your family a lot of headache later on. The healthcare directive and the power of attorney, this is the planning for incapacity piece. These documents are only effective during your lifetime, and the healthcare directive and the power of attorney are documents that I strongly suggest that anyone who is over 18 have. You may say to yourself, well, I really don't have any assets. I'm just starting out in life. I'm a young person. Well, they always have the risk that something might happen to you, a car accident or something, where you're unable to make healthcare decisions for yourself. So having a healthcare directive puts the people in place to do that for you. It used to be in Georgia, probably about 15 years ago, that the healthcare directive was known as a living will. There were two documents. There was a durable power of attorney for healthcare, and that document named your agents that could speak for you when you can't speak for yourself. And then there was a living will that provided the guidance on a couple of end-of-life situations and what you might want to have happen to you if you were terminally ill. The Georgia legislature got together and decided we need one uniform document that handles both of these things at once. So I think it was about 15 years ago or so, where they combined the two documents, and now it's called the Georgia Advanced Directive for Healthcare. And in it, you name your agents. I suggest always that you have backups. So there's going to be a primary agent that's going to make the decisions. And then I suggest you have two backups. Oftentimes, married couples will their spouse will be the first person, and maybe their children will be behind them. Well, we have to think about who's going to be in the car with us if something happens. So we want to make sure that we've got a good list of backups so that there's options in the event that someone is unavailable. And then the other thing to know about the healthcare directive is that it's only effective when you cannot speak for yourself. So this does not authorize somebody to come in while you're alive and with capacity and, you know, able to make your own decisions and say, no, wait, stop, don't do that treatment you're going to do. This, the document is only intended to allow people to speak for you when you cannot speak for yourself. Um, so, and I would urge also that you may think, I don't really need one, you know, traditionally the law steps in and says, okay, well, the spouse might be the person that speaks for you, or if you're don't have a spouse and your parents are still alive, your parents might be the person that speaks for you. But there are people out there that don't have great family relationships, or the person that might be the legal person that could speak for them might not be the one that they want making their healthcare decisions. Their values may not be aligned. So if you are that person and you want somebody special, a partner that you have that is not going to be recognized as a spouse if you're not married, and not be able to make decisions for you. If you want that partner to be your healthcare agent, you need to have a healthcare directive and have that in there. All right, so moving on. So we've got the power of attorney, which is another document that deals with incapacity. So again, the healthcare directive and the power of attorney are only effective while you're alive. The power of attorney is the document that puts people in place that can help with financial issues. So calling insurance companies, going to the bank and writing checks for you, doing things like that. And the power of attorney can be effective either immediately, so that, you know, somebody, you go out of town, you say you travel for work a lot, and maybe sometimes you're in a remote location and can't be reached. Your power of attorney can be immediately effective, so your primary agent can step in and help with things while you're in that situation and out of town and need their assistance. Or it can be springing, so you can put a regulation on there that says that only if I'm incapacitated could anybody listed in this document use it. Again, just like the healthcare directive, it names the agents that can speak for you, and then it indicates the extent of their authority. So it says these are the topics of which my power of attorney has authority to deal with. And we can add additional topics. Let's say you're a sole business owner and you don't have anybody else that signs on your bank accounts, and something were to happen to you where you become incapacitated, you might consider adding a special power to your power of attorney to allow somebody else to transact on your business bank accounts if necessary, in the event that you can't, to help kind of keep your business going during that period of incapacity. Another important thing to know about the power of attorney and the healthcare directive is that copies are just as good as originals. So nobody's going to need your fancier blue-backed original signed document in order to be able to use it. And a power of attorney is a document that is very powerful. I mean, it can allow somebody to come in, you know, if you give them the power to do so, to come in and clean out your bank account. So this is a document that I always recommend to clients, unlike the healthcare directive, that I want everybody to have. So everybody is really clear on who the healthcare agents are. I don't want you to spread your power of attorney around, because you may change things and it may not be necessary for someone to have one. And really, if you needed somebody to do something for you, all you needed to do would be to email them a copy of it. So it's good to kind of keep it in a safe place until somebody actually needs it. And again, anyone over 18 should have one of these. So they can be for very specific tasks, but most of the time when I'm doing a power of attorney, they're general. And again, they are state specific. If you're traveling and you need somebody to do something who's with you on the trip, and you need your agent to do it, most likely that power of attorney is going to be honored because you're only temporarily in that state. But if you move, you should talk about, do I have an effective power of attorney for where I live right now? I've already talked about immediately versus springing. And then sometimes you hear the word durable related to powers of attorney. That means that it remains effective even after you're incapacitated. So if you did not have a durable power of attorney, and all of the powers of attorney that we do in our office are durable. If you had one that was not durable, that means that if you were to become incapacitated, it no longer would have effect. Okay, so let's talk about the will. What is a will? A will is a person's declaration in writing of how he or she wants their property to be distributed after their death. And it puts people in place that for executors, if you have minor children, it's where you name the guardians for your children. And it's a great place to make bequests to individuals or organizations that you care about. I want to leave $10,000 to Trees Atlanta upon my death, or I want to leave $100,000 to Trees Atlanta upon my death. You can do that in your will. It's a great place to do that. We're going to talk about in a few minutes other ways to be able to do that gifting, but this is a great place to do it. And it also is where we set out the rules with regard to your estate and how it's going to be handled. So the will have no effect until after your death. So the documents that are in play before your death are your health care and your power of attorney. The will comes into effect after your death. What is the difference between a trust and a will? So we get this question all the time, and there's a lot of people out there on the internet talking about, or your friends and neighbors, I have a trust, you should have a trust, everybody should have a trust. So let's kind of hopefully clear up a little bit of the confusion about what a trust is. What a trust is it is a mechanism for separating out the person who is in control over an asset versus the person who's going to benefit from an asset. That was the ultimate purpose of a trust way back when. That, has gotten a little bit convoluted now because oftentimes people will have trusts and the same person that is benefiting from the trust is also in charge of the money. But the idea has kind of originated from the idea of, I have young children and I don't want them to inherit $1 million outright when I die. So I want to set up a trust to hold that money for them. And I'm going to put somebody else in charge of it until they reach a certain age so that they won't, frivolously spend it. I will tell you the statistics show, and our clients show that we've had much experience with this, where somebody inherits a bunch of money outright. It's usually gone within 6 months after they've inherited it. So having a trust could be a good way of making sure that does not happen. It is definitely appropriate and should be used when there is a situation where control over the asset and benefit of the asset should not be with the same person, like the minor child example. Like the example here is maybe you name your sister as trustee over the money that you want to leave to your niece and nephew. So you could leave them $10,000 or more than that and say when they turn 30, then everything goes to them outright. But in the meantime, my sister is going to be in control of the money and use it for their benefit until they turn 30. So we often hear terms like revocable and irrevocable with trusts, and some people have heard the term and may be familiar with the term inter vivos, and some may be familiar with testamentary. So let's kind of divvy up what those mean right here. So inter vivos just means a trust that you're making while you're alive. So a revocable trust that you are the trustee over your own assets during your lifetime. That's an example of an inter vivos trust. A testamentary trust is a trust that you might put in your will or in your revocable trust that says, after my death, this trust is going to come into play for my children. So testamentary means that it's after death, essentially, and made in your will is where you typically find it. And inter vivos just means it's a trust that you set up to hold your assets while you're alive. Revocable versus irrevocable, I imagine most of you can figure out. One means, revocable means you can terminate it, but it also means you can amend it. You can buy and sell assets out of it. The assets that you hold in your revocable trust are just like you have them now as an individual. That's all managed under your own social security number, and you can do whatever you want with the assets in a revocable trust. An irrevocable trust is used typically for tax planning. So that means that assets are put it out of your control if you have an irrevocable trust. You're giving the control over those assets to somebody else, and you're maybe you're considered to have been gifting that asset to the irrevocable trust. And then the beneficiaries of it, maybe it is something that happens during your lifetime, or maybe it's something that happens after your death, but it's a way to move assets out of your taxable estate. Most of us now don't really have a reason to do that. Because right now the personal exemption amount is going to be $15 million. It's 13 or 14.9, somewhere in there right now. It's going to be going up and increase for the rate of inflation over time. So if you own $15 million worth of assets or less that you're passing, you're not going to be subject to estate tax. So we have a lesser need to do a lot of irrevocable planning to avoid estate tax. It used to be years ago, like if you look back at 2000, even in 2010 or 11, the exemption was 2 million. So if all you had to have was $1 million life insurance policy and $1 million home, and you were already in the taxable estate level. So a lot of people used irrevocable trust to plan for that. We're seeing that less and less now as people, because there's also a thing called portability. So if you are married and you have your own $15 million exemption, and your spouse also has a $15 million exemption. So collectively, you can have $30 million of assets before there's any sort of estate tax. So for the purposes of this discussion, we don't need to talk about irrevocable trust very much, but when I talk about trusts now going forward, I'm talking about revocable trusts. So what's the purpose of a revocable trust? Why have one? The main purpose that I see people coming to our office to have and asking for a revocable trust for is to avoid probate. And I'll tell you, this is legitimately one of the few things that a revocable trust can do. It's not going to help you avoid creditors. Yeah, maybe it'll slow them down a little bit because there's no public filing of your trust. So they may not know that there's money in your trust to go after your death to pay off debts. But if they did and they found that out, or if your executor and trustee know of debts, they're going to have to be paid out of your trust. So this is not a means of you stashing away money that's not going to be touched by creditors. Really, the purpose for it is avoiding probate. And in Georgia, there's about 4 reasons where you might want to avoid probate and use it. One, a big one, is if you own out-of-state property. If you own a vacation home in Florida, or a second home somewhere else that you're renting, or you might want to consider having that property held in a trust, because that way if upon your death, we can avoid a probate in that state where that home is located. So if you have a Florida vacation home, there would need to be Florida probate for that piece of property. And if we name it to your trust, even though your trust is here in Georgia, then we can avoid probate in Florida. And there's lots of states where probate is a very cumbersome process, and it's expensive and takes a long time. But in Georgia, generally speaking, the courts are slow. I can't argue with that. It's since COVID, things have not been anywhere near as efficient as they used to be. But generally, probate in Georgia, if you have a good will that waives the things that would normally require court involvement, the court's only involvement is going to be getting you appointed as the executor, or getting the person who you chose appointed as the executor, and then at the end discharging the estate. So I would say that for a lot of people here who may think that they want or need a trust, it's really good to talk to a lawyer about it, because it may be a cumbersome and expensive thing for you to set up in your estate that you probably don't even need. So but there are reasons to have them. So avoiding probate is one of them. And you may want to avoid probate because maybe you're disinheriting a child, or you've got complicated family dynamics. And what happens when you do file that petition for probate with the court is the people that would have inherited your estate if you didn't have a will, those are called your legal heirs. They're not your beneficiaries, they're your legal heirs. Those people would have to sign off on that petition for probate approving the executor. So if we want to avoid that process, we want to have a revocable trust. But there may be other reasons. You may have had poor experiences with probate in the past or other issues that may make you decide you want to avoid probate. So having a revocable trust could be a good consideration for you. One of the more underrated uses of having a revocable trust is planning for incapacity. We talked about the healthcare directive and the power of attorney. And if you were to become incapacitated, your power of attorney will help with a lot, but it'll be one-off uses. You'd present the power of attorney once, do that transaction. The next time you go to do something else, you got to go back and present the power of attorney again for that person. And that just repeats on and on. If you set up all of your assets in a revocable trust, then you have successor trustees that come in if you become incapacitated. Those successor trustees are pretty seamlessly appointed with a one-page document. And then they can step in and kind of seamlessly handle that the assets in the trust in the event of your incapacity. So it is, especially our older clients that maybe are experiencing a dementia diagnosis or already having memory loss and kind of feel like they need some backup support from their kids and things like that. Having your assets in a trust may be an easier way for them to do that. And then also it allows for privacy. So your will is going to be publicly filed. If your will says I'm leaving $500,000 to my son and $500,000 to Trees Atlanta, maybe you don't want everybody in the public who searches those records to know that your son just inherited $500,000. You might be less concerned about people knowing that you gave that much to Trees Atlanta, but you may not want them to know your son just received that. So instead, what we do is we say in your will, I leave everything to my revocable trust, and your trust that is not publicly filed then has the gift for your son listed in there from that. So to keep us kind of rolling on time, let me just move on to some other ways that assets pass in addition to using your will and your trust. So you have other tools in your tool bucket for doing estate planning. And those are titles to things, and there are also beneficiary designations or versions of those. Let's talk about the titles first. So let's take your deed to your home. You have, let's say you and your spouse own your home jointly with right of survivorship. That means at the time of your death, the title to your home will pass 100% to the surviving spouse. It happens by operation of law. There's really nothing else that needs to be done except for maybe filing an affidavit with the death certificate in the property records to have it kind of cemented in there. But that is one way that property can pass that doesn't involve probate. It doesn't involve your will or a trust. It just happens because the deed says that property is owned jointly with right of survivorship. The other example would be a joint bank account. So you have a bank account that's titled to you and your spouse, then that account is going to go to the surviving spouse at death. It's going to happen automatically. Another mechanism for passing assets is beneficiary designations. And this is kind of getting to the heart of talking about the gifting piece of this. Life insurance policies, retirement accounts have beneficiary designations on them. And then you have your bank accounts where you can have what is called a payable on death or a POD, which is the equivalent of a beneficiary designation. Your brokerage accounts that you might have with your Schwab or Fidelity would be a TOD, a transfer on death. So those transfers on death and payable on death designations work just like the beneficiary designations. Generally, what happens when you use a beneficiary designation is the asset will pass directly to that beneficiary without the need for any sort of probate. So they would just present a death certificate and a claim form, and they would receive that asset. If you don't name a beneficiary, then what's happening is that asset is coming into your probate estate. So it is a good way to pass assets to help them avoid probate. And those assets that you pass out directly to other people are generally far less susceptible to being touched by creditors than your assets that you put in your trust or your will. So if you have a big life insurance policy and you have a lot of debt, you may want to pass that life insurance policy out to a beneficiary, and it's less likely that they're going to go after that money to try to retrieve it. I can't promise you they won't for sure. It just depends on what the debt is and who the creditor is, but that is a better way to do it. The disadvantage, retirement accounts, we talked about, I mentioned retirement accounts have beneficiary designations. If you do not have individuals or organizations on your retirement assets, your pre-tax stuff, your IRAs, your 401ks, your simple employee plans, then what'll happen is that money will come into your estate, and the income that has to come off of it is going to be taxed at the estate tax rate, which is 40%, and not at the individual tax rate. So if you left it to your sister and your sister's tax bracket is 20%, or you decided, I'm just going to let my estate figure it out, and you left it to your estate is going to have to pay that income tax at a much higher rate. And the other issue is that there is a stretch out period. Like oftentimes when you leave it to specific individuals, like your spouse has their whole lifetime to draw down on that account. So they don't have to take it out at once and get that big income tax hit at once. Anybody else that you leave it to that is not a minor child or a disabled person has 10 years to draw it out. You leave it to your estate, at most it's going to be 5, it may be even less than that. So it is much more tax efficient to make sure individuals and organizations are named as beneficiaries. And when I talk about organizations on your retirement amount, your retirement accounts, using your beneficiary designations for those charitable gifts is the biggest bang for the buck for the charity, because they don't pay any income tax when it comes out. They don't have to worry about stretching it out. And it is a great gift for them. So if you're thinking about doing charitable gifting in your estate plan, you may want to think about, instead of maybe putting a bequest in your will, naming that charity as a beneficiary of one of your taxable accounts. Okay, so plan giving. Let's dive into that. What is it? Well, first of all, it's just what it sounds like. It's giving with a plan. You're establishing now what you want to do for an organization later on. This is, of course, there's outright things that we can do right now where we can give cash and things to organizations, but those of us that want to leave a legacy and we want to, share our values with our family for charitable giving, having charitable giving and plan giving as part of your estate plan is a great way to do that. So you set up the plan now to say, upon my death, this is what's going to happen. It's done as part of your overall estate plan, whether it's beneficiary designations or it's in the will or a trust. You can do it any of those ways. It's also often called deferred gifting or estate gifting or legacy gifts. You can use them to honor a loved one. I've had clients that name an organization that means the world to them and says, I'm giving this gift in the honor of my sister or my mother. And that is ordinarily recognized by the organization when that happens. And you can also choose oftentimes the very specific programs you're interested in supporting. So you can direct that the funds go to a very specific program within an organization when you're doing it as part of your will or your trust. So there are many ways to do this, and I've kind of touched on a few of them, but let's kind of go through the long list here of the different ways to do it. So first of all, there's outright gifts that you do during a lifetime. You can give cash, you can give personal property. We all think about what we bring to Goodwill every couple of months. So that's an example of using personal property for this. Securities. It's a great way if you have stock or securities that have appreciated and you're trying to avoid some capital gain tax. Using those securities, appreciated securities, and giving them to charity is a great way to handle that. Real estate. You can often donate real estate to charities during your lifetime. Donor advised funds. This is a big one that I really strongly suggest for my clients, is that I have a lot of charitably inclined clients that come to my office, and they have a number of charities that they want to list in their wills. Well, a donor advised fund is a fund that you set up with, there's a variety of organizations, your Schwab, your Fidelity, your Raymond James, they all have their own version of a donor advised fund, sometimes called a DAF, DAF. And there's also like the community foundation has it's a donor advised fund. Depending on where you go, it really, kind of depends about what the minimum is to start it. Usually with your Schwabs and Fidelities, there is no minimum, or it's very small. With some organizations, it's you have to, start it with a large cash gift. But basically, you set up this fund during your lifetime, and you can identify the different charities that are meaningful to you as the beneficiaries of the donor advised fund. And then, oftentimes our values change as we age, and the people and the organizations we want to support change. They do that. You just adjust your list on the donor advised fund instead of coming back to me and paying me as your estate lawyer to update your will and change that list. I have clients that are constantly changing their list of charities that they want to support. And I really strongly encourage them, why don't you get a donor advised fund? This will make it a lot less expensive for you. You can have backup administrators of it. It's a great tool. There's also trusts that you can do, charitable remainder trust and charitable lead trust that you can do that leave money for charity or give money to charity now and leave money to your estate later. I don't do a lot of that tax plan. It's considered somewhat tax planning, and which is a little bit out of my realm, but I definitely have folks that could help with that if that's something you were interested in doing. The plan giving at death. So again, we're talking about charitable bequests that you make in your will. I leave $100,000 to Trees Atlanta. And then there's also beneficiary designations where you just say, I leave 10% or 50% to whatever organization that calls to your heart. And then there's also, a lot of people don't think about this, but for a lot of younger people that may be charitably inclined, you could, life insurance at a young age is inexpensive. And you could make the charity or charities that you want beneficiaries on a life insurance policy is a great way to do it also. And again, when you set up those beneficiary designations, be it for life insurance or your retirement account or a brokerage account, whatever, it is another time where you can easily change those without having to get your estate planning attorney involved in that process. Other methods, and I have CPA friends that talk about this all the time, is making qualified charitable deductions from your IRA. Your required minimum distributions, which once you get to a certain age, which I think it varies, maybe 73 and a half right now, it may be changing, that you have to take money out of you have to start taking money out of your retirement account. And there is a required minimum distribution that comes out of your account. Well, you can use those required minimum distributions for charitable gifts, get the tax write-off, and take care of your charity at the same time. So that's an excellent way to do it. Transfer on death deeds. I have this on the list. It is not my favorite option for this. This is a way to do real estate generally. And you could set up a deed for a piece of real estate that has it passing to a charity. The law in Georgia on transfer and death deeds is not very good right now. It is a brand new thing that has come into play it's about a year and a half old now. And the law wasn't written very well. So they're working on changes to it. And I think once it gets a little better, it'll be a good way to transfer real estate to charities if you wanted to do it, or to your loved ones. But right now, it is not the best way to do it. And then, of course, you can give gifts of partial interest. Like if you own stake in something and you wanted to give somebody a charitable organization a piece of it, you could do that. So when is a gift not just a gift? I mean, charitable giving is a profound statement that provides for the causes that matter to you most. It honors the values that have guided your life, and it creates a charitable legacy that endures. It really is. I have clients that have set up their documents and left a pool of money for their family to continue charitable giving after their death. I'm so touched and honored to work with them. And, it is really a great way to take care of the causes that you love. And you're all here because you're members of Trees Atlanta and you love this organization as much as everyone here in this room does. And I hope that you would think about the idea of making a legacy gift as part of your planning. Well, that is it for my talk, but I am happy to take on whatever questions. I have a few questions that were passed on to me before we started, but let's see what we've got. I think you can raise a hand and we'll take your questions now. I think we're going to stop recording as well.